Hello friends, in the series on the income tax cases, today I will discuss a very important case on demonetization which is related to the assessment year 17-18. The name of the judgment is Eagle Fleet Services versus Assistant Commissioner of Income Tax, and this case has been reported in 105 ITAT Tribunal, page number 78, short notes, and the matter has been decided by Chennai ITAT A bench, and the date of the judgment is 19th July 2023. The purpose of discussing this case is that this case will have a very positive impression for the assessees who are fighting their case for the demonetization period, in which they have accepted as payment the specified banking notes which was not a legal tender money at that time. Before starting my discussion on this case, I just want to say that whenever I read the judgments from the Income Tax Reporter, which is a publication of Company Law Institute of India Private Limited, in that cases, whatever the short notes are given, that are really very crisp and very helpful for any professional or for any businessman or the legal fraternity who are handling the matters of the income tax. So I get a lot of enrichment from those short notes. In this case, the matter was related to the assessment year 17-18. The assessee was in the business of plying car services on hire charges. During the demonetization period, the assessee received near about 75 lakh rupees in specified banking notes. Specified banking notes means the notes which were in the denomination of rupees 500 and 1000, which were prohibited to accept as a payment for any amount during the demonetization period. When this amount was received by the assessee deposited that amount into the bank account. It was also clear from the facts and records of the assessee that during the same preceding year, during the demonetization period corresponding to the preceding previous year, the assessee has also deposited almost the same amount into the bank account. So it can be safely presumed that the assessee was regularly depositing cash into his bank accounts. But the assessing officer, before making the addition of the assessee, gave the reason that the assessee has received these specified banking notes which was not a legal tender money. So the addition under section 69A is justified, and he made the addition of the full amount which was deposited into the bank account in the form of specified banking notes. Even the CIT appeal upheld the order of the assessing officer. So when this matter came before the ITAT said that there is no distinction in section 69A between the legal tender money or the money which is prohibited to be received in the demonetization period. So the addition made only on the basis that this amount was not a legal tender is not justified. But at the same time, the ITAT said that since the assessee is not in a position to distinguish and clearly elaborate that what amount has been received from the services and what amount was available with the assessee, there was no clear records. So the assessee should not be left with scot-free, and 50% of the addition should be done in the interest of justice. Friends, although in this case the assessee escaped from 50% addition, but this is a landmark case because it somehow allows the assessees to accept the money in the specified banking notes which was not a legal tender money at that time, and the assessee can save his skin by taking the shelter of this judgment. At the end of this video, once again I am repeating the name of the case. The name of the case is Legal Fleet Services versus Assistant Commissioner of Income Tax, and this case has been reported in 105 ITR Tribunal, short note 78. The matter has been decided by Chennai ITAT A bench, and the date of the judgment is 19th July 2023. Thank you, friends.